So, yeah, good morning, everybody, and I'll echo what Kevin and Pam have both said, and we'd like to welcome you to the session. We appreciate you being here today. It's obviously been a very strange couple of years that we've all had. That's true across the board for both the industry and for us as the regulator. So we thought it was a good opportunity to put some things out that we saw over these last couple of years. Some things are there's not been a lot of change in the statute or the rules, but certainly how some things have happened. So I wanted to provide you a quick little brief roadmap of the session, what we're going to go through today. And as Pam mentioned, just go through an overview of examination matters and topics. There's really not going to be anything that you haven't seen before or haven't heard of before, but just to lay some things out again in a very clear way, give you an opportunity to take in the information, see the applicable statutory citations or the rule citations, and have that opportunity then to ask some questions I mentioned. Anna will touch on some legal issues that both we sometimes see and that we try to keep an eye on an ongoing basis as things that might emerge, and as mentioned, a Q&A. So with that, I'm just going to go ahead and jump right into it. Anna, could you take this one?
No, what we wanted to make clear is that we're discussing topics today, but they're not official interpretations or guidance. We're trying to go through the legal requirements so that you have some guidance as far as how to operate, but as far as specific guidance, you will need to contact your own legal counsel because every business is different and we can't provide one size fits all guidance, but we do hope to provide you some guidance that will help you in going forward and doing your business and avoiding any compliance issues that you might have. Jeff, did I cover that?
Yep, absolutely. Thank you. So we're just going to roll into the first topic here. So certainly, as I mentioned, this is something that came up quite a bit over the last couple of years, and I think we have a poll question for this one to kick it off. So what if you do have that issue that comes up where you have the change in the posted hours of operation? Give everyone a little bit of time to roll through that.
And I'll go ahead and read off this question. If there is a change in a pawnbroker's posted hours of operation, how many days notice must be provided to the division? There are a few options and we'll kind of see what everyone thinks about that. Okay, the responses are still coming in. So far, the lead answer is 7 days, 71% of the responses. Now 80% of the responses says 7 days. The next, well, there's a tie then for 5 and 3 days and 0 responses for 4 days. So Jeff, do you want to go ahead and give the answer to that?
So the answer is actually 5 days. 5 calendar days before the effective date of the change. And so again, being in writing, that can be by email, in person, mail, or fax. And I should give a quick note at the end of the presentation, we'll provide you all the contact information that will be useful for this type of notification or any of the others that we're going to discuss. And as Pam mentioned, this will be posted so you'll have access to everything. And I'll give you the statutory citations for these, both the revised code and the Ohio Administrative Code sections that address this. Now, obviously, this is a change that you know about in advance, for sure. So if it's something that you're aware of, you know somebody's going to be out of town, you know there's going to be, some type of maybe maintenance work that's being done at your location, and you're going to have to change the hours, that's the type of notification we're talking about here. There's certainly emergencies, unforeseen issues, somebody has car trouble, can't get in to open the store on time, that's a very different situation. Obviously, we understand that occurs, and again, the last 2 years have shown that a lot, that we had a lot of things that we worked through with shops and with owners to get changes in posted hours, get that just known, basically, because an emergency is an emergency. By definition, you can't know 5 days in advance. With that said, it is still helpful to get notification to the division as soon as possible if you do have that emergency where you're not open for, until noon on a given day when you're normally open at 9. That's helpful information for us to know and be communicated, because if we by chance happen to get a complaint a consumer reaches out to say, hey, I went to go in and make a payment or try to redeem an item, and the shop was closed, but it was during the normal business hours. That's helpful for us to know, because then we can refer to that notification you provided to document what that emergency was in that situation. Okay, so we're going to move on. How about a pending move of the business location? What's the story there? What type of notification is required? That's also a prior notification to DFI of at least 30 days before the date of the move. And that needs to be provided in writing, and the same methods do apply as mentioned on the prior slide. And there are your statutory citations for that. Quick note about the citations we're going to put up here. There are sometimes, as you know from looking through the statute or looking through the rule, there are areas of overlap where the statute will address something and the rule will address the same thing, or maybe just expand on it a little bit more. There might be other statutory sections that apply. We just wanted to try to keep things as streamlined as possible when providing these cites to you for reference. All right, and I think we have another poll question here, Pam. For closure of the business, what's the notification requirement there?
Okay, and the next question is, if a pawnbroker business is closing permanently, how much notification must be given to the division? 5 days, 7 days, 14 days, or 30 days? Okay, so far it's 100%. Everyone agrees that it is 30 days.
And that is correct. Yeah, prior notification to DFI of at least 30 days. And note that's 30 days, not 30 business days, 30 calendar days, just 30 days. So the statute is clear on that one. So, so I think, Pam, we have a poll question for this too, correct?
Yeah, that is correct.
Okay. So before the closure date, the pawnbroker or the shop must do one of the following with respect to what has to happen with closure of the business.
The possible answers here are transfer active loans by selling to another licensed pawnbroker, reduce the rate of interest to 8% or less effective on the date the license is no longer valid, either A or B, or both A and B. Okay, so far there's 100% agreement on this question. Oh, well, now not 100%. 86% say it is both A and B, and this is ever changing. So now it's 9% say either A or B.
Okay, the answers pretty much stopped rolling in at this point?
Yeah.
Okay. So the answer is, these were the options, and that's the answer. It's one of the following: dispose of the active loans by selling to another licensed pawnbroker, or reduce the rate of interest to 8% or less effective on the date the license is no longer valid. And the notification that we referenced of at least 30 days is in writing. Again, that's the same methods as before, so you sense a theme coming with this. And there are your statutory citations for that closure process. Okay, so moving away from notification and communication, I'm going to step into item descriptions a little bit. And this is pretty straightforward. There's really not a ton that we need to say about this. It is something that we do still note in exams. And you know, we're aware that sometimes there's a lot going on in the shop, and it can be hectic, and you can have a lot of people backed up. But we do need to stress this is what the code requires. I'm not going to read it to you because I think it should be against the law for someone to read what is on a PowerPoint for you to take a look at either now or in the future. But the note that we would offer to you, just as a practice point, is most everything has something that fits somewhere into this definition. A television has a size. A piece of jewelry, typically, chain, has a length. A ring would have a colored stone. It would have a size. So we just want you to be thinking in those terms that pretty much everything that's coming in is going to have something that can be described that would meet the standard on the statute. You know, the thing that we sometimes do see in exams and that I see when I'm reviewing reports is something like gold ring, gold chain, television, game system, things like that that need to go a couple levels deeper in the description because that's just going to help everybody as that process goes forward. And there is your statutory citation for that. So moving on to the information that's required on pawn and purchase forms. So the following information is needed. Again, I'm not going to read all these. They are pretty straightforward. These are pulled directly from the statute. And it's continuing here. We do occasionally get questions on the identification piece, and what's, I think that might be one of the questions that was submitted in the Q&A, so we could probably address that a little bit later. The physical description of the pledger or seller is another one where we do occasionally see that that's not necessarily as complete as it possibly could be, but just wanted to call out that is noted as a requirement in the statute. And again, we just saw this on the prior slide. However, because it is in that section of the code, I did want to be complete and include that. And there's the statutory citation for that piece. Moving on to record keeping and retention, I think we've got another poll question here.
Okay, our next question is a true or false. A copy of each form used in pawn or purchase must be kept in an active or inactive file. Okay, so far, around 94% of the responses are saying it's true and 6% are saying it is false.
Okay. So I'm sorry, Pam, could you read the question again just so I make sure I get it right?
It's true and false. A copy of each form used in pawn purchase must be kept in an active or inactive file.
Correct. Okay, gotcha. Thank you. So that answer is true. So that is required by the code, an active and inactive file. That is one of the questions that we did receive in the lead up to the event today. So we may address that as well if anybody would like to speak to that a little bit more, clarify that following the session. And also the note of what the code requires with respect to separate pawn and purchase forms, and you have the statutory citation for both of those there. So moving on for record keeping, bit more on record keeping. Records and forms are required to be kept at the licensed location at all times and available for inspection by DFI or law enforcement. And I do want to note that DFI exams are going to be during business hours. That's just the way that's going to go. We can't speak necessarily to law enforcement and what their process may be, but that's generally going to be the case as well from our conversations with them. The all times in that section of the code refers to the records and forms being there. So there shouldn't be a scenario where an examiner comes in for an exam or law enforcement comes in to pick up daily reporting and, oh, I have to go pick up the records. They're at a storage unit or they're somewhere else. They're at some other office. That's just what the code requires. They have to be there at all times. Okay, I think we have a poll question here. A little bit more on record keeping and retention.
Okay, the next poll question is another true or false. A customer may sign a blank or partially complete pawn form or record. Okay, so far 100% of the votes are saying it is false.
All right. Fantastic. That is correct. It is false. The code does not permit a shop to require a customer to sign a blank or partially complete pawn form or other record. And I know from speaking to a few of you over time, this is something that sometimes customers push for. Oh, I don't remember this. I don't have this piece of information. Can I just do this part of it? And the answer is no. It's just not something the code permits. And there's your statutory citation for that section. And the other piece to note for record keeping and retention is maintaining your books, forms, accounts, and records for at least 2 years after the final entry on the account. Obviously, if that's a purchase, that is as of the day that you purchase it. If it's a pawn, it's whenever that final entry is noted on that. And there's the statutory citation there. So the code does make clear that you are free to use other methods of recording data and keeping records, provided that hard copies or printouts of the information are readily available. And I know a lot of you work directly with your examiners on how best to get that information provided and taken care of, but we did want to make clear the code is clear that that's permissible under this section right here. Okay. All right, we're going to move on to item retention, and we've got another poll question here.
Okay, the next poll question is all pledged and purchased items must be stored at the license location unless, first answer is you run out of space. Second, you prefer another method. 3, you plan on selling it on eBay. Or 4, or the pledger agrees otherwise.
Getting a sense of how those are coming in?
Yeah, it is 67% right now. The pledger agrees otherwise. 11% for you run out of space or you prefer another method. And 6% you plan on selling it on eBay.
Okay. The answer is it's the fourth option, unless the pledger agrees otherwise in writing at the time that the pledge is made. So again, obviously purchases are a separate matter with respect to that type of retention. There's another one that we'll get to here in a moment, but all pledges would have to be kept at the licensed place of business unless the pledger agrees otherwise in writing at that time. There's also a note in the code that the pledged vehicle, watercraft, or outboard motor may be stored elsewhere upon notification to the pledger, but you do have to take possession of the item and the certificate of title. And there's your statutory citation for those. And Anna, could I turn this last bullet point over to you?
Sorry, I was muted. Which one are you referring to?
So this one where we're referencing just the distinction in the retention time period.
Oh, regarding the difference between the pawnbroker and the Precious Metal Act?
Yep.
Yeah, I mean, I guess there's not a lot to say about it, but if you are acting as a precious metal dealer, as a pawnbroker, you still have to follow the retention schedule that's required as a pawnbroker. So you know, just because you're doing precious metals does not give you that 5-day retention period. You still have to follow the 15-day. And if you want to follow the 5-day, then just apply for a precious metal license. And then you'll be able to move that stuff along quicker. But you need to have the extra license. You can't just piggyback off of the pawnbroker license to say, oh, I'm doing precious metals, so I can only follow the 5-day. Jeff, does that kind
It
of
does,
get
yes.
to what you.
Yep, thank you very much, because that's a point that we do still get some questions on, because the feeling is, well, this is precious metals activity, so it's only a 5-day retention period. However, if you're using your pawnbroker license, as Anna said, to act as a precious metals dealer, then those Pawnbroker Act requirements do have to be followed. And the statutory citation is right up there in 472712A. And Anna?
I would add something too. I know it's an extra cost to get a precious metal license, but once you've been approved probably for your pawnbroker license, it's probably going to be smooth sailing if you want to get a precious metal license so that you can do that.
Mm-hmm. Yeah, good note.
Does that?
For sure. Okay. Well, Anna, I think at this point, we can go ahead and turn some of this over to you. I'll just add the quick note here of what we have, that there's not any permission in the code. The code actually prohibits removal of any pledge from the licensed place of business for any personal use or gain, and the statutory citation is there for that. Okay. So Anna, I think at this point, we're kind of moving away from the examination related topic, so I think we can go ahead and turn this over to you.
Are you looking at, say, slide 14? Do we have survey questions first?
Not for that one. We took care of that one.
Okay.
So we're on to 15 now.
Okay. So yeah, the daily reporting is that you need to report to law enforcement a description of all the property pledged or purchased, the number of the pawn or purchase form to document the pledge or purchase. Now, you need to have a good description there. It as Jeff was saying earlier, it can't just be gold ring. It has to be class ring from 1987 with this color of a stone, that kind of thing. And the thing that we wanted to stress here is that law enforcement, different agencies that you work with will have different requirements working with you. Some may want to pick it up every week, some may want to pick it up every day. And as long as you're working with your local law enforcement team to make sure you're in compliance with them, then you will wind up being in compliance with us. As long as you are, you know, taking care of what you need to take care of locally, we're not going to mess around with, well, you didn't give it to them every day, and then you're saying, well, they don't want to get it every day. We just want to know that you are complying with the local law enforcement. And you have to use, though, this is the other thing, is you have to use the format or form that they require. So if your local law enforcement agency wants you to email stuff, then you email the stuff. If they want paper forms, if they give you a form that you fill out, then you have to do what they say to do. And, you know, again, to reiterate, and I know Jeff and I keep going back and forth and on about this, but when everything says in writing, it can be electronically. So it can be communicated to law enforcement electronically and, you know, by other methods.
Yeah, this is a common thing when we, I'm sorry, go ahead, Anna.
No, I was just going to say, Jeff, do you have anything to add?
Oh, okay, thanks. It's a common thing when we get contact from, you know, a city law director or a city attorney's office or law enforcement about, you know, us requiring law enforcement to pick up their daily reporting in a certain way, and we don't have that requirement. The code says daily. However, that's not a reality in a lot of places, as Anna said, where law enforcement is simply not going to come pick it up every day. And our take is absolutely what she said. If you are cooperating and dealing with them in the way they are hoping to accomplish this, then we have no concerns whatsoever, because we can't hold you responsible for a daily reporting requirement when law enforcement comes in weekly or biweekly to grab those records. So it's just a common point of discussion. We thought it was valuable to mention here. So Anna, I'm going to roll on to the next with respect to potentially stolen items.
Yeah, so if law enforcement provides you notification in writing that you are sitting on a potentially stolen item, then you have to keep that item for 30 days past your reporting date to law enforcement, unless they say it's no longer necessary to retain it. So law enforcement can put that hold on there for you. And you will have to maintain it and retain it. And if someone comes back to try to redeem the pawn, you have to say no. And I know that is difficult, and that in and of itself may wind up a call to law enforcement if someone's trying to redeem a stolen pawn. So just be aware of that. And then the other issues that can arise with potentially stolen items. So what if law enforcement takes a stolen property report and identifies the true owner? Okay, so if law enforcement notifies you, say you take a pawn from Lisa, and law enforcement tells you that the pawn belongs to Katie, and you have the option of restoring that property to Katie, okay? If you decide not to do that, then you can sue the person who pawned the item to get the money. Actually, if you restore the property, you can sue the person who pawned it for the money. Now, I know this isn't like a good option. None of these are good options here, just so we know. None of it's good. And so, you know, if you return it to the claimant, then you can go ahead and sue the person who, like I said, sue the person who sold it to you. So I think that, you know, you have two options. Basically, you can either return it to the person who you believe to be the rightful owner, because law enforcement may come to you and say, we believe that, what name did I use? I can't remember.
Katie.
Not Lisa. Lisa was the person who pawned it. Jeff, who was the person
Katie.
Katie, thank you. All right,
Mm-hmm.
Law enforcement come to you and say, Katie, we believe Katie is the rightful owner. And you can choose to restore her to that and give that to her, and then you can sue Lisa. But the other thing is that, and we understand as DFI, we're not law enforcement and we're kind of the middleman here, but we understand that you may say, well, how do we know that Katie's the rightful owner and not Lisa? And we don't want to restore it. So this is a difficult question, and one that if you find yourself in this situation, you really probably should consult private counsel. Jeff, what would you add to what I just said?
Yeah, I would echo that. We will try to help to the extent possible, and I think everyone who's on this call who's dealt with this situation would know that, exactly to Anna's point, that certain proof that's submitted for someone being the true owner, certain proof is better than other. Yeah, I've seen cases where someone came in with a photo of themselves wearing a watch or a ring or an item of jewelry. That's pretty strong. You know, you can make that pretty clear. If it's a he said, she said scenario, but law enforcement feels very strident that they've found the true owner, that's a very difficult situation for the shop owner to be in, because as Anna said, you have two choices, and that's the code section, that's 472712C. You may restore the allegedly stolen property to the claimant, to Katie in her example, but the important part to note is if you elect not to restore it, the claimant, who is Katie in that example, could potentially sue you for restoration of the property. And I'm not even going to get into, some of the other tactics that you might face and things like that if you elect to go ahead and hold on to that property. But then, as Anna noted, if you return it to the claimant directly, you may charge the person who sold or pledged the allegedly stolen property, as well as anyone who acted with that person to defraud you, because that's what happened. They claimed to be the owner, they defrauded you, they exacted some sum of money from you under false pretenses. That's the pretty much textbook definition of fraud. Now, we are very mindful, and we discussed this at length when we were putting this presentation together, that if a thief comes in and sells something to you or pledges something to you, the likelihood that you're going to be able to find that thief again to present them with a bill for the money that you're out, or that you'll even be able to find them at whatever address they gave, probably pretty low. So we are very mindful of that. We are only presenting this as what the code says. To Anna's point, not that we're viewing either of these as good situations. Pawn law and ownership is a very unique area of the law. It's still largely controlled by a very old Ohio Supreme Court case from, I want to say, 1960. Is still one of the most influential and largely controlling things that dictates what happens in this scenario. So that's just kind of a strange place to be, particularly when you're trying to think about how to operate your shop on a daily basis with the flow of goods that come in and out, and doing your best to work with those folks that bring items in. And, under this, we'll talk about this here in a few minutes, but under this is an undercurrent of some due diligence requirement for your employees and for anybody who's taking in goods to ask a few questions about how something has come in. If there seems to be kind of a story that doesn't quite add up, or the person is not quite sure or can't really say how they acquired the item, that's one of those things that operationally is probably a good practice point to advise your employees on that. So, Anna, I think we covered that. We'll probably get some questions on it, but I think we covered it the best we can right now.
Yeah, I think so.
Okay, so I'm going to move on for you to redemption and forfeiture and the mailing of notices.
Okay, do we have a survey question first?
Yeah.
We do. Mm-hmm.
Okay. The next full question is, what is the time frame for forfeiture after mailing the required notice? First response is none. Possession is immediate. Second is pawnbroker may choose. Third is 15 days from the mail date. And fourth, 30 days from the mail date. Okay, looks like right now 100% of the responses are 30 days from the mail date.
Okay, fantastic. And Anna, feel free to jump in on this one, but just we wanted to offer some quick comments.
I'll go jump in. I was just looking at the chat, and we got a question here about, I thought we could just reclaim the loan amount from the original owner. And if the original owner wants to pay that amount, that's fine. You can accept that. You're not forced to do anything here. You can say no. If they come in, that's the ideal situation, actually. If the original owner comes in and wants to pay the pledge amount, then you get the money you were expecting to get, they get their item back, and everybody's done with it. So that's an ideal situation. But if you have a situation where the original owner is wanting it back and they don't want to pay the money, is where you start getting into the problems. Did I sort of hit on that question? I can put a more specific answer in the chat later. But yeah, and I think a lot of original owners are willing to just pay the amount just to get the item back, because usually it's for a lot less than the item is valued, either monetarily or sentimental. they are often willing to pay it. I've known a few people who have had house break-ins and they've gone to the local pawn shops and found some of their family jewelry there. And all they wanted to do was just pay the pawnbroker and just get the item back.
Yep. And another scenario that's unfortunately a little bit too common is where it's a family member that's involved, and maybe it's something that's lifted from a grandparent's house or something like that, and the family member has no interest in involving law enforcement, and that can be precisely that scenario that Anna talked about, where I just want to be done with this. I've got my item back, no harm, no foul. And really from a logistical standpoint, that is the best case scenario, that the shop is not out the money that it either spent on the purchase or expected to get on the pledge, and the true owner has got their item back. So it's unfortunate that is a reality, and we do have to be mindful of that. It's a scenario that I see actually quite a bit in talking with law enforcement, that sometimes they want charges to be pressed, and it's just not going to happen, which ultimately doesn't fix the situation, but at least for the immediate thing of getting the person their item back, that's something that can happen.
Yeah. And I guess, Jeff, you kind of open up a different can of worms, because if you've got an estate situation and someone's claiming to be the true owner, then as the pawnbroker, without law enforcement backing, and even with that, how do you know if there's, say, my mom dies and then her ring winds up in a pawn shop somehow, and I've got me and my 4 siblings trying to say we're the rightful owner? You guys shouldn't be involved in that, and don't get involved in that. That's the only legal advice I'm going to give this whole time.
Yeah.
Call a lawyer. You got that?
Situation.
Call a lawyer.
Mm-hmm. Okay. Anna, was there anything else you wanted to mention on the mailing of notices? I think it's a pretty straightforward requirement, and we have the code section in there, so I can move on to some of the prohibitions and enforcement issues if you're ready.
Yeah, we were just going to say that, the noticing of the forfeiture mailings have to be done. We said 30 days. I think that came out in the polling question, but also the fact that they need to be done, have a return address that coincides with the place that the person made the pawn. So if they made the pawn in Cincinnati, Ohio, that address has to be Cincinnati, Ohio pawn shop XYZ. It can't come from the central company that is out of, say, Oklahoma. So that person knows that they're getting something that has to do with their property, and they don't think that it's sort of a mailing, like I don't know, but I want to say spam, but that's not the right word. What's the word for snail mail stuff? That,
like a solicitation?
Thank you. Yeah. So that's all I have.
Okay, sure. And the other thing that we'll note too, I don't think it's a secret right now that the U.S. Postal Service is having its challenges. So that's another area to just take into account when you think about your logistics and operational decisions for mailing. Is there something that needs to be padded on to the beginning of this process so that you can be sure you hit that 30-day mark? Making sure that when things have been picked up, delivered, signed, anything like that. Because the code doesn't it says 30 days. It doesn't say 30 days, but maybe 45 if the mail is slow, and we know it is right now. So that there's really nothing any of us can do about that, because we have a 30-day clock that we have to watch. You have mailing issues that you run into. We have to figure out how to work together to solve those things. So that's the only practice point we can really offer you, is to keep in mind, if there are going to be delays with mailing, just keep that 30-day clock in mind. And if you think there may be some problems, we're happy to talk you through, some potential solutions with that. So we'll go ahead and move on to some prohibitions and enforcement issues. And I'll turn these over to you.
Okay, where are we here? I'm sorry, I was trying to answer a question in the chat.
Oh, that's okay. 19.
Got distracted.
No problem. We're on 19.
Okay, so Yeah, so this is pretty straightforward. I mean, I know most of you know, you can't take a pledge or purchase anything from a minor or a person intoxicated or under the influence, if that's obvious to you. And you have to check ID, so you'll at least know about a minor. And, if you know someone's out there and they're bringing you a whole bunch of like new in the box kind of stuff, and, you just get this spidey sense about, oh, I think this person's stealing stuff, then that's what this bullet point goes to. The second bullet point is, known or believed to be a thief or receiver of stolen property. Well, this isn't the one where law enforcement notifies you. This is the one where you say, okay, in the neighborhood, this person is known to be a thief, and they're on drugs and they steal stuff and they want to come in here and sell it to us so that they can get money and they can go buy drugs. So just watch out for those people, because that can get you in trouble. And the presentation this afternoon will speak to that. And then the other thing is, this is clear cut. If you're notified in writing by law enforcement that a person is a thief, and known to be a receiver of stolen property, that kind of thing. If you're notified by law enforcement about this person, then just stay away from them, because that's all kinds of trouble right there, because that's black and white.
Mm-hmm. And this goes back to, Ann, I think you've laid that out really well. It goes back to the point of the due diligence piece, where if the story is just not adding up and how something came in, that's really one of those things where you don't want to let business walk out the door, certainly, but some of the issues that could arise, and not even speaking directly to DFI, but some potentially criminal implications coming out of that situation, particularly as Anna noted. I don't think we can hit this enough. If law enforcement notifies you in writing of a scenario where someone is a thief or receiver of stolen property, and then that person winds up doing business with your shop, that's more along the lines of a criminal aspect. Is definitely not a good scenario.
Yeah.
Okay.
So, and then moving to 20.
Yep.
So basically, if anyone who is a licensee or an employee or manager gets a conviction for a violation of the Pawnbroker Act, or a criminal conviction for theft, receiving stolen property, or money laundering, and Jeff has the code section laid out here for you, the division can suspend your license without a hearing. And then what would happen is your license would be suspended at that point, and you can't do any business as far as pawn business at that point. And then the division would proceed with an administrative hearing to revoke the license based on that stuff. But it can be immediately suspended with no hearing if one of those instances occurs.
Yeah, and I think the point to hit on here really clearly is certainly a criminal conviction for a violation of the Pawnbroker Act. So that might be what we just discussed, where law enforcement notifies you in writing and a pledge or a purchase happens with that person. That's very potentially where a prosecutor might proceed with a criminal case for a violation of the Ohio Pawnbroker Act. So I don't want it to be confusing to say, oh, well, DFI is assigning some type of criminal conviction. That's not the case at all. It's just a specific
Right.
criminal conviction specific to the Pawnbroker Act. Or then if you go outside the Pawnbroker Act, the criminal conviction for theft, receiving stolen property, or money laundering, things that are very, very specific to the business that a pawn shop does, that being theft or RSP or money laundering, those things. And that's why it's sort of leveled up a little bit in terms of seriousness with respect to that automatic suspension without a hearing, and then proceeding with potential license revocation in those two scenarios. So we'll move on
Right.
to the other.
That's good clarification. I think that it's good to understand that those are convictions that would come, not anything to do with DFI. They would be something that would come from the criminal justice system, like, you know, the county prosecutor's office or the city prosecutor's office locally where you're located with your pawn shop, or where the person committed the crime, for that matter, even if it's in Oklahoma. I think I'm picking on Oklahoma, and I don't know why.
Oklahoma and Lisa.
Yeah, I know. Lisa's my best friend too, so she'll love it. So the other thing is, if there is a criminal conviction, like we just said, Jeff and I, outside of DFI, this is the criminal justice system for any jurisdiction in the United States or territories. Then the division may, after having a notice for a hearing, either assess a penalty or revoke the license. So if an employee gets a minor crime, say an assault or something, the division could take action and either assess a penalty or suspend or revoke the license involved with the licensee or the employee.
Yeah, I think it's important to highlight the difference between this slide and the slide before, where those other criminal convictions were so significant, either violations of the Pawnbroker Act at a criminal level or theft, RSP, money laundering, triggering that automatic suspension without a hearing. And this is not to say that these other types of convictions would be less serious. You know, who knows what the crime might have been, but they don't touch on the activities contemplated in the Pawnbroker Act. So that's why it sets forth the notice and the hearing opportunity, where the shop would have an opportunity to come in through its attorney and explain what happened in that scenario. So I think that is just about all we had in terms of the material that we wanted to present. And we can go ahead and roll into a few questions. If we've gotten some in the chat, we can go through that, or anybody wants to go,
Jeff,
go out.
And Jeff and Anna?
Yeah.
Yes, we have a handful of questions. First question in chat is from Harvey Lerner. Consumer privacy concerns with the daily reporting requirements. Misuse by law enforcement causes concerns. Is Ohio Legal Department discussing the required reporting? Word about after 30 days.
Anna, I'll touch on this from an exam perspective, and then we can figure out where we want to go from there. From the legal side, I will say we are always talking about this because it is one of these areas that is very tricky for us to navigate. No one needs to feel sorry for us, but we are put in the middle of a lot of these situations by the code. And law enforcement wants things done a certain way, and the code doesn't always specify that certain way. I'm trying to be very careful with my words here, so someone can cut my mic if I'm saying too much. But that's one of the challenges, where once that information leaves your shop via daily reporting, whenever that might be picked up, that's a very real concern. And we get that. That is part of our conversation about how can we try to have these discussions with law enforcement too, and present, here's what the code actually says, here's what the code requires. You bring up a really good point in this question, because if you remember back to one of the slides talking about the information that must be on the pawn and the purchase form, one of those, and it's in the code, is any other disclosures required by federal law. So there may be something that you're required to disclose in terms of privacy under the GLBA or something along those lines, or potential FTC notification. So these are very real things that you have to deal with. I will say I do not believe we have had very in-depth conversations about potentially changing the reporting requirement, because it is in the statute. And as everybody knows, it's difficult to get legislative change passed through on a very specific point like this without having some larger revision of the Pawnbroker Act. Anna, would you add anything to that?
No, I think you covered it very well.
Okay.
I'm in agreement.
Okay. And, you know, there's not much more I can say, but I get the import of the question. It's just, we are not in the position to direct law enforcement how to pick up use, handle their the reporting that they get. Our piece of it is simply to ensure that it is happening. We don't even really facilitate it. We just try to help the discussions move forward where we can make sure it's happening. And I think it goes back to what Anna said earlier, that if you're doing what law enforcement wants you to do with respect to reporting, you're going to be fine with us. These larger questions about what happens to the information after it's out of your shop and it's been reported to law enforcement, that's just not an area that we have really any visibility over, unfortunately.
And I guess I will add something to that. Having been a prosecutor for so many years, law enforcement, they have rules as far as privacy and personal information and everything also that they have to follow. And so, yes, I'm sure that it happens occasionally that law enforcement would misuse information or leak information or do something like that. We all know that these things happen, but in general, they are governed by a similar statute of confidentiality that we are governed by as DFI. So they really shouldn't be releasing this stuff. And, you know, if that comes to your attention, then certainly let us know, you know, and we can maybe open a dialogue with that agency if they're leaking stuff out that they shouldn't be, and also go up the chain of command and everything, because we don't want this to be a problem for you guys either. So, you know, I would just say that, you know, feel a little better in terms of the fact that they are governed by similar privacy requirements.
Next question is from Anand Haveri. It's two parts. What if you have an item that was claimed stolen, that was a jewelry piece, but then the customer never comes to get the stolen item? And what would the wait period be if the original owner never comes to claim the stolen item?
I think it goes to the normal wait period if no one comes to claim it. I'm a little confused by the question in terms of an item that's claimed stolen, a jewelry piece, but then the customer never comes to get it. Is that referring to the person who pawned it or the person who is supposedly the rightful owner? I guess I'm a little confused by that. But the retention period, Jeff, correct me if I'm wrong, but I think the retention period is still the same.
That would be my understanding, as long as the retention period was honored from the beginning and met. And I guess the other point of clarification I would ask on this question, did law enforcement provide notification? Did they come in and say, we found the true owner, hold it, and then the true owner never comes back in and you can't get back a hold of law enforcement? Because that is a scenario that I have seen occur.
Yes.
So I guess in that situation, I would be just documenting the entire thing. Law enforcement came in on X date, provided this notification. I held for 30 plus days. No one ever came back in, can't get a hold of law enforcement. You know, at that point, that's really all you have left. It's really all you have left is to say, well, we honored this, we did everything the code requires. And, you know, at that point, I don't know what other choice you have other than to just follow your normal procedures. Now, that's not to say that you wouldn't face issues down the road. I have seen a scenario where someone came in, a law enforcement officer came in 6-8 months after the initial report was taken, and the item was held for 30 days, and then the shop owner just went back to the regular retention schedule, and the item was no longer there. Tried to make a big fuss about it, and we got involved because the question was, well, they sold this item that we told was stolen, and we had to walk them through. It's a 30-day hold. So if your case is not to the point where you can get something more concrete or you can get some resolution within 30 days, like, again, we're not picking sides here. We're just calling the balls and strikes about what the code says. But it's yet another tricky situation. That's a recurring theme in any of the stuff we're going to talk about.
I think it is. And also, you know, this brings up a good question in terms of just, falling back on what the original hold time is, and also document. If you're in a situation where you feel like things are squishy, like involving a stolen item, just document everything you do. And so that's there when you need it, if you need it. And hopefully you won't. But if you do, then at least you will have a chronology of how you handled the situation and what you did.
Yep.
And so, Jeff, I think that's really good advice.
Yeah, and I think
we're not going to be able to deal with every situation individually, and neither we can't anticipate, and neither can any of you on this call anticipate what might come up in your shop.
correct. And to underscore, and I don't mean to sound like there's nothing we can do, because we will always help to try and navigate these tricky issues when they come up and mediate with law enforcement things that we can. But you can be totally fine with us with respect to the Pawnbroker Act, and law enforcement or a city attorney's office may still decide they have a problem. And I don't think I'm breaking any news in saying that. That's not to say anybody's doing anything wrong or bad. They just are approaching it from a different side, right? I mean, I see Anna smiling, and I think it's just, they are approaching things from a criminal justice perspective. We are approaching things from a general regulatory compliance perspective. And we, trust me on this, that we get asked to intervene in situations many, many times, and we say we can't because the requirements of the code, the requirements of the rules are being met. That's all we can tell them. And we don't go into any more detail. Like, we don't go into this should happen, this shouldn't happen. It's just the code. It is what it is.
You're absolutely right, Jeff. But I will say, don't hesitate to contact us if you find yourself in a situation like that. Mm-hmm. We probably can't help you out of it, but at least we'll know what's going on.
Right. And it can help take the temperature down a little bit, because if there's an officer on one side of the counter and your manager is trying to deal with the scenario in the heat of the moment, that can get out of hand. You know, that can be difficult. And sometimes us stepping in can help take the temperature down a little bit, where we can engage with a police legal advisor, potentially a city attorney's office or a prosecutor, to say, hey, you know, let me just show you the receipts in the code here. This is what the code requires. This is what they did. And
right.
You're not trying to slug it out in the moment. And I know that's a hard situation, but we do want to offer that assistance where we can.
Okay, next, I believe this is a question from Carrie Duckworth. I thought we could reclaim just the loan amount from the original owner. Yes, most are more than happy to get, I would assume, the property back. When Carrie said to get it back, I'm presuming it meant the property.
Yeah, I think I kind of touched on that because I saw this question come in, and you know, what I said was, yes, of course, if the original owner wants to come in and pay for it and get it back, then that's great. But just be aware that, you know, if it's a situation, like I said, where there's several siblings or something going on, that you could wind up, you know, if you give it to one and then the second one comes in and says it should have been mine, you know, so you don't want to wind up in that situation. But if you know the people, because I know a lot of the pawnbrokers that are on this call know their clients. And if you know that, you know, so-and-so had one son and he comes in and says, my dad died, this is, you know, this is mine, then you can feel more safe. But always touch base with a lawyer if you can on those situations.
I'll also note, Harvey in the chat made a really good point that a home insurance policy, a homeowner's policy, could pay the redemption amount potentially. If an item is stolen out of your home, that could potentially be covered in that way. And I think Carrie's absolutely right. And that's the situation that Anna said. If the original owner comes in and wants to give you the money you paid, that's the end of the situation as far as I think the code or anything is concerned. You don't get into those too complicated scenarios because you've got your money back. The original owner has their property, and most are very happy to get the item back.
I agree. From our standpoint, that ends the scenario. I guess I was branching out too much into like civil law and what might happen. But I think that home insurance is a good really a good point that somebody who's wanting to get it back but doesn't have the money, they could maybe use the homeowner's insurance or a life insurance policy to get it back.
Mhm.
Okay. Aaron Mersak asked, can you redeem it to someone claiming it was stolen claiming it is stolen without a police report?
Yeah, you certainly could. You know, and whether that's the situation that Anna talked about where you know the person, you know the customer, you have a really good feeling, or they provide you some type of good evidence, a photo or something like that, you absolutely can. You don't have to wait for that process for law enforcement to become involved. If they come in and, you know, they can provide that and you feel comfortable with that, absolutely.
Yep, I agree. Nothing to add to that. That was the one I was responding to when I got distracted, and that was exactly what I was going to say. Thanks, Jeff.
Yeah, sure.
Okay, I think this has been answered, but Harvey Lerner asked, after the 30-day period, can we proceed to forfeit or sell?
Yeah, I think we touched on that, but let us know if we did not. You know, I think this goes back to Anna's point of document, spoke to law enforcement on this date, received notification, held for 30+ days. Now here we are, attempted to call multiple times and are, you know, not getting any response, have no idea where the case stands. That's just all the helpful information. It's really not, I mean, it's for our purposes. We would probably be interested to see that in an exam, just so you can document what happened. But, you know, again, we're just falling back on what the code says, because the code does not address what happens if law enforcement doesn't come back in. It's not an indefinite hold. It's a 30-day hold, unless they tell you that it can be released earlier. So it's not an indefinite thing. And it does put the onus on law enforcement to kind of have their ducks in a row, for lack of a better term, and be ready to move this to some type of resolution, because the law recognizes that pawn shops have an ownership interest in the items that they have either received as pledges or have purchased. Would you add anything, Anna?
No, that's great. Yeah, I agree totally.
Okay, Adam King asked, what happens if the police try to take the item?
So I think this is where my team's is going to crash. I'm just going to let Anna take this one. I'm kidding. Yeah, this is the hardest situation. This probably is the phone calls I get where there is an active situation that needs resolved, it's this. There's really no guidance that we can give you on this other than to say, potentially think about having a copy of the code sitting at the counter. Let your managers know, let your employees know, this is what the law says. But it happens a lot. I get this call way too much, unfortunately, where a shop calls or law enforcement calls, and you know, we're put in that uncomfortable middle spot of, this is what the code says. There are two options. The shop has the option to restore it, and the shop has the option to hold on to it and potentially be sued by the claimant. I am fully aware, being careful with my words here, I'm fully aware that sometimes law enforcement takes a pretty aggressive approach to this and demanding that they take the item, or saying that, you know, well, if I don't get this item back, you're not going to like the next, you know, few weeks outside your shop, or the presence that we're going to have. There is unfortunately nothing we can do about that other than to have those escalated conversations, as Anna mentioned, and say that, you know, hey, here's what the code says. The pawnbroker is completely within their rights to take this course of action. And that's where we have to leave it, unfortunately. Anna, I don't know if you have anything else, but it's a tricky scenario.
I think everything you said, I would agree with. And this is a scenario where you can call us as, you know, as your licensing agency, and we can run interference a bit to the extent that we can. The other thing I would say is, if the police are trying to take the item and they have a warrant for it, then you are legally covered, and you just give them the item and get a copy of the warrant. If it's that kind of scenario where it comes down to them having a warrant for it, then you just have to give it to them. And there's you know, there's nothing else beyond that. Jeff, do you agree?
Absolutely. And at that point, this is, I think, the recurring theme we've said several times throughout the morning here. At that point, you're outside of the Pawnbroker Act. You're in the criminal justice process there, and you're just kind of along for the ride. So that supersedes, and at that point, you're adhering to that and what those requirements are. But if it's just somebody coming in to say, I fully believe this item is stolen, and they have nothing more than the person's say-so of that, that's when we fall into this gray area of the code, that you have the opportunity, if you buy the story, if you believe it, if you just want to do, what you think is the right or the nice thing, free to do it. If they want to pay you, they are free to do that. If you are just not comfortable with the scenarios presented, you fall into the second piece of that section of the code.
Yeah.
So I don't think we got to everything, but we will have the Q&A at the end of the day.
Both will take a look at those questions and maybe respond in the chat. That would be appreciated. We're going to take a break now, and we'll reconvene at 11 o'clock.
Okay.
Thanks,
everybody.
You.
Thanks, Phil.
Thank you.
Thank
Excellent
you.
job.